Welcome to Talking Foreign Policy. During the past 3 months, the United States Navy has conducted airstrikes against 22 foreign vessels off the coast of Latin America suspected of transporting narcotics, killing 83 people. President Trump asserts that these military attacks are a lawful exercise of the international law right of self-defense against drug cartels. And he has notified the U.S. Congress that the United States is engaged in an armed conflict with the cartels, thereby justifying lethal force. This is an extraordinary development, even for an administration that does startling things every day. I'm your host, Michael Scharf, former Dean of Case Western Reserve University School of Law and President of the American branch of the International Law Association. To discuss the significant legal and policy implications of these attacks, I have assembled an exceptional panel of experts. From New Haven, Connecticut, we are joined by Harold Hongju Ko, former Dean of Yale Law School, who served as Assistant Secretary of State for Democracy, Human Rights, and Labor during the Clinton administration, and as the legal advisor of the Department of State during the Obama administration. Harold, thanks for being with us once again on Talking Foreign Policy.
Thanks.
Now, from New York City, we are joined by Rebecca Ingber, who is a professor of law at Cardozo Law School and a senior fellow at the Reese Center on Law and Security at NYU School of Law. From 2021 to 2023, Rebecca served as the counselor on international law in the Office of the Legal Advisor at the Department of State. Welcome to our program, Rebecca.
Thanks for having me on, Michael.
And I'm also happy to welcome back Milena Stereo, Distinguished University Professor of Cleveland State University College of Law and Managing Director of the Public International Law and Policy Group, who is joining us today from the Florida Keys. It's always good to have you on our show, Milena.
It's always a pleasure to participate, Michael.
And finally, with us from Cape Cod, Massachusetts, is U.S. Navy Captain retired Greg Noon. He's the director of the Fairmont State University National Security and Intelligence Program, and he's the former head of the International Law Branch at the Pentagon. Welcome to our show, Greg.
Pleasure to be here, Michael.
So let's kick things off with Milena Stereo. Milena, can you provide us some factual background as to why the Trump administration is using the U.S. military to attack Venezuelan vessels in the Caribbean Sea? I mean, what's Trump's beef with Nicolas Maduro, the president of Venezuela?
Well, Michael, the Trump administration is alleging that there are these narco trafficking boats originating from Venezuela that are smuggling drugs into the United States illegally, and the Trump administration is thus alleging that the United States is an armed conflict with these narco traffickers who are coming from Venezuela. Now, I do think that President Trump, as you said, has beef with Nicolas Maduro, the Venezuelan president. Maduro is a leftist president who has been aligned with countries that are not necessarily allies of the United States. And so that is one reason for the fact that the Trump administration is against the Maduro regime. And actually, some have accused the United States of using these airstrikes as a pretext for actually trying to seek regime change in Venezuela. But I do think that there's also a personal aspect to this. President Maduro has regularly weighed in against President Trump, and I do think that President Trump, in addition to all these perhaps more objective reasons to be against Maduro, has personal animosity towards Maduro. And then last, I would mention, as most of our listeners probably know, that Venezuela has significant oil resources and that it is in the U.S. interest for Venezuela to be ruled by a leader who is aligned with the United States.
Milena, is it also true that President Maduro has been indicted in the United States federal courts for conspiracy to traffic narcotics?
Yes, that is also true, and there is a $50 million bounty on his head. And so some of the allegations that have surfaced recently against the Trump administration is that with the U.S. administration using these strikes against Venezuela, this will lead to regime change in Venezuela, because either Maduro will be so rattled that he will self-deport, decide to step down, or that somebody will oust him and try to collect that $50 million bounty on his head.
All right, but it's not just Venezuela. The United States has also attacked Colombian vessels over on the eastern Pacific. What's the history there, Milena?
Well, the history there is perhaps a little bit different in the sense that Colombia and the United States had a fairly friendly relationship for several decades. And in fact, Colombia was one of the main beneficiaries of U.S. aid in the early 2000s with the particular plan, money going towards Colombia called Plan Colombia. And this was a U.S.-funded initiative to combat drug trafficking groups, which did reduce the flow of drugs to the United States, and some credit this financial aid by the United States with weakening various guerrilla groups in Colombia, including the notorious FARC guerrilla group. However, more recently, Colombia has been ruled by a more leftist president as well. His name is Gustavo Petro, and there is, again, personal animosity between President Petro and President Trump. President Petro harshly criticized the Trump administration's strikes against Venezuelan boats. He called them illegal. He called it tyranny. And perhaps in response to that, President Trump threatened to cut off aid to Colombia and, in fact, did implement some cuts to Colombia as of September. And then this did open the door to ultimately the Trump administration deciding to also use airstrikes against some of these boats coming from Colombia in the Pacific, again, with this allegation that these are narco trafficking boats and that the United States is in armed conflict with these Colombian narco terrorists, in addition to those coming from Venezuela.
All right, I want to sort of get a picture of what these attacks are like. So let's turn to Captain Greg Noon. Based on what you're reading, how is the United States conducting the attacks against the Venezuelan and Colombian vessels? Can you describe these operations for our listeners?
Yeah, absolutely. And first, I'd like to just kind of dovetail what Milena was just saying. Most of the drugs going to Venezuela are headed to Europe. That's not where the fentanyl is coming from, which is one of the things that President Trump talks about often. The cocaine coming out of Colombia, that comes to the United States. The fentanyl, mainly from China, and that's coming across through various points of entry. So just kind of a picture of where the drug trade is going. Look, we're tracking everything that's moving in the ocean all around our country. And particularly down in what we, for many decades, referred to as the 7th District, which is the Coast Guard district that does Florida and the Gulf of Mexico, everything coming from that side of that side of Panama. We have a lot of platforms up there that are looking at everything that's moving, and frankly, the strikes are being done mainly by MQ-9 Reaper drones, typically armed with Hellfire missiles. But other strikes, I'm sure, are being done by fighter jets or AC-130 gunships.
So in these cases, there are no warnings, no arrests, no evidence recovered. Is that right?
That's correct. And that's problematic because not only the evidence recovered, but the intel that's recovered. Everything down to the cell phones, down to the human beings that we pick up in a typical takedown of boats like this. That's how we build out what the picture looks like for what the network is, where they're coming from, who's doing what. So in the long term, we're losing out on a significant amount of intelligence that ordinarily we'd collect when we do a typical boarding, as opposed to these strikes that are just eliminating the boat altogether.
All right. And Venezuela's president, Nicolas Maduro, and Colombia's president, Gustavo Petro, they have complained that these attacks against their vessels are a violation of their sovereignty because they are flagged vessels. And they also say that they constitute extrajudicial killings. Greg, tell us about the concept of flagging a vessel. How do we know that these are, in fact, Venezuelan and Colombian flagged vessels?
Yeah, so flagging a vessel is where the ship is registered. And now
they don't actually fly a big flag that says Venezuela or Colombia. Well, it's just a little stamp on their registration.
Sometimes they do, sometimes they don't. But that's not what's supposed to happen when they don't, right? So looking at these videos that have been released, it doesn't appear that there's any visible flag or any sign of registry on the boat itself. See, all boats are registered, right? At least legally operated boats are registered. So it doesn't appear that there's anything that's indicating where they may or may not be flagged. But the proper thing to do under international law would be to approach and board them for purposes of verifying what their nationality is, what the boat's nationality is. And if they're Venezuelan or Colombian flagged, we would then get authorization to search, seize, arrest, and prosecute. But if they're not flagged in any country because they're completely outside the law, then we would force our own law of search, seizure, arrest, and prosecution.
But Greg, if they're not flagged, doesn't that make them pirate vessels? And if that's the case, doesn't the U.S. have a right to fire on pirate vessels on the high seas?
Yeah, bottom line up front, they're not pirate vessels, right? So, as you know, under international law, UN Convention on Law of the Sea has a very specific definition of piracy, and it doesn't have anything to do with being flagged. So, under Article 101, piracy is defined as any illegal act of violence, detention, or depredation committed for private ends by the crew of a private ship against another ship, their persons, property, etc., either on the high seas or in any place outside of a state's jurisdiction. So this activity is not piracy in the legal definition.
All right,
of piracy.
thanks for clearing that up. So let's look at the law of war. By way of background, there are two branches of international law that applies to attacks. They have fancy Latin names that provide the rules related to the use of force. So let's turn to Milena Stereo. Milena, can you tell us about the difference between jus ad bellum and jus in bello?
Sure, Michael. So jus ad bellum are international law rules that govern the initiation of the use of force. In other words, when is it legal for states to use force against each other? As a general matter under international law, in light of the UN Charter as well as customary law, the use of force is prohibited other than in two exceptions, which are if states have UN Security Council authorizations to use force or if states are using force in self-defense. So that is jus ad bellum. Now, once there is an armed conflict, once states or non-state actors have initiated the use of force, then the rules of so-called jus in bello govern and restrict ways in which states as well as non-state actors are allowed or not allowed to use force. So, for example, jus in bello imposes on states and non-state actors the duty to respect various principles, such as, for example, the principle of distinctions, which says that you can only intentionally attack military targets. You cannot intentionally attack civilians. And so, again, jus ad bellum are rules that have to do with the initiation, when is it legal for states to use force, and jus in bello applies once there's an armed conflict, and it restricts ways in which force can be used by states or non-state actors.
So let's dig into this a little bit, and starting with the issue of jus ad bellum. Rebecca, the Trump administration has claimed that it is justified in using deadly force against the Venezuelan and Colombian vessels based on the United States' right of self-defense, which is recognized in Article 51 of the UN Charter. What would the Trump administration have to prove to justify its attacks under the law of self-defense?
Thanks, Michael. So this is that macro question that Milena was just talking about, the jus ad bellum, the question of when states can use force in the first place in what would otherwise be violation of the UN Charter's prohibition on the use of force. And so the UN Charter has these two very, very narrow exceptions to when a state may use force. And one of them is a UN Security Council resolution, which we obviously don't see here. And the other, which is relevant here because it's what the administration is claiming, is self-defense to an armed attack. And so this is what you're asking about specifically. And when a state has been the victim of an armed attack, it may use force. It may use only that force that is necessary and proportionate to repel that attack. And this piece is important because you can't just do anything just because you've been attacked. The state can only do what is necessary and proportionate to stopping those attacks. And generally speaking, when we're talking about Article 51 self-defense, we're talking about the use of force against states. When we're talking about non-state actors, when we're talking about individuals, we're typically, and violence that might be committed by individuals, that's typically mere criminal activity. And when states are addressing mere criminal activity, including criminal activity that includes violence, states normally address this through law enforcement measures. And international law, and international human rights law in particular, does regulate the use of force in those contexts. But that is the norm, that is the normal framework that we think about when we're thinking about state use of force against individuals as opposed to against other states. So for example, if we're talking about people allegedly smuggling drugs, the normal way to address this, just as Greg was mentioning, is through interdiction, confiscation perhaps of any actual drugs, and potentially prosecution. But there have been limited circumstances historically when states, and in particular the United States, has used force against a non-state actor that has attacked us. And the attacks of 9/11, I think, are the key example to think about. So Al-Qaeda attacked the Twin Towers, the Pentagon, airplanes, and there was widespread acceptance at that time, including in the Security Council, widespread international acceptance that the attacks of 9/11 were an armed attack that justified the use of force in self-defense, despite the fact that it came from a non-state actor. But we were talking there about an actual organized armed group, Al-Qaeda, with an actual military hierarchy and command structure and capability to engage in those kinds of attacks that actually attacked this country in attacks that rose to a significant level of gravity. In fact, those were the most significant attacks on the homeland since Pearl Harbor. And so in the cases involving these alleged drug smugglers, we have none of these factors. We have no organized armed group. We certainly have no armed attack. And so there's no armed attack against which the United States could be acting in self-defense. But there's a reason the president wants to use a wartime framing for drug smuggling. There are political reasons, but there are also legal reasons. And the legal reasons are that the legal framework for operations against suspected criminals is simple law enforcement. It would not permit these kinds of attacks. And the summary execution of mere suspected criminals is unlawful under international law. It's an extrajudicial killing. And under domestic law, it's murder. And so he is attempting to cram these acts that are, in fact, extrajudicial killings under a legal framework that doesn't fit.
All right, so I want to build on what Rebecca was just saying. On the issue of the use of force against non-state actors, we're actually lucky to have the world's foremost expert on this issue here with us on the air. So let's bring in former State Department legal advisor Harold Koh into this conversation. Harold, when you were the legal advisor during the Obama administration, you articulated the rationale for the targeted killings of members of the Al-Qaeda terrorist organization when they were in a country that was unable or unwilling to suppress the threat that they posed to the United States. And that argument was subsequently used by the United States to justify airstrikes against members of the ISIS terrorist organization in Syria, and then more recently against the Houthis in Yemen. How, Harold, is the Trump administration's attacks against the Venezuelan and Colombian vessels on the high seas different from those precedents which you helped establish?
Yes, well, thank you for asking the question, because the speech I gave 15 years ago was followed by extensive debate within both the Obama and the Biden administration. So the Obama administration set forth a detailed set of rules in 2016 called the Presidential Policy Guidance or Playbook. And then the Obama administration reiterated them in 2021. Both of these memos are presidential guide apparently by Trump. But the differences are obvious. First, as Rebecca said, there's no war. A war on drugs is not a war against a particular terrorist network, and you can't bomb your way out of a war on drugs. There is no self-defense rationale. As she said, no organized armed group, no armed attack, no imminent threat. There is no authorization for the use of force enacted by Congress. It's not happening against identified senior operational leaders, which is what targeting is about. Absolutely nobody on the boat has been identified except for the people who have been rescued. There is no proof that anyone has committed any illegality. So many people on board. They seem more likely to be refugee boats than drug boats. And then, as Rebecca pointed out, even if all of it being alleged is true, it would not be the basis for subjecting them to execution. That would be done following a full trial and proof beyond a reasonable doubt. But even those crimes do not yield capital punishment. So there is no proportionality, there's no distinction. Every rationale of both international law and domestic law that ordinarily apply does not apply in this situation, which leads you to the conclusion, as Rebecca put it, that this is simply summary execution being carried out against a bunch of boats, and we have no idea who these people are.
Well, I think that puts that issue to rest. Let's now talk about the principles of jus in bello, the rules for the conduct of armed conflict. So I guess we have to assume for a moment that this is now an armed conflict. For the past 20 years, the United States has pursued a less lethal approach to narco vessels. I think Greg was alluding to this earlier. Coast Guard helicopter-based marksmen would disable engines on fleeing drug boats, allowing suspects to be arrested, evidence to be recovered, and intelligence to be gathered. So, Captain Greg Noon, do the rules of warfare applicable in armed conflict permit the United States to fire missiles and destroy the Venezuelan and Colombian ships because they are transporting narcotics?
No. So the first question in targeting under the law of armed conflict, under your assumption, if there was in fact an armed conflict, is are they military objectives? And unless they are military objectives, you cannot target them. And there's really, given the information that we have, there's nothing that would support that they would have a role in such hostilities. So the short answer is no. And to your longer point about how it would be done is you would order a vessel to stop, you would fire a warning shot if necessary, and then again, if necessary, you could disable the engine. And this is through the Hytron program, where we have marksmen on helicopters that can disable a weapon with a 50 caliber precision rifle. So there's a process that we've been following for decades in this. But even in the arguing in the alternative that if this was an armed conflict, you couldn't simply blow them out of the water.
And yet, that is what they're doing. So it's been reported that despite the fact that these attacks are being done with missiles, that one of the attacks resulted in the capture of 2 survivors. I suppose they just jumped overboard and were swimming. They were temporarily detained by U.S. naval forces, and then the United States released them. Greg, if Secretary of Defense Hegseth said, no, that's not what we want to be doing, so he orders the Navy not to rescue any other survivors of the U.S. airstrikes, would that be an unlawful order?
100%. And that would be an unlawful order that by rule, no one in the United States military would be required to follow. The just following orders defense, as you know, is not a defense. And the fact of the matter is it's something that is patently illegal, such as in order not to pick up survivors, which is a well-established rule in international law, maritime law. You have a duty at sea to pick up survivors. And that would absolutely be an unlawful order. And frankly, I don't know of any Navy captain, any Navy commanding officer, or Coast Guard commanding officer that I know, that I've worked with, that I've been at sea with, would ever follow that order from anyone to not pick up survivors.
Well, and I think since Nuremberg, this has been an uncontroversial position. But last week, when a group of Democratic lawmakers who were former military officers issued a video reminding U.S. military personnel of their obligation to disobey an illegal order, President Trump accused those lawmakers of sedition and said that their actions were punishable by death. Greg, why should we be troubled by that?
On so many different levels, Michael. From the First Amendment right on through to everything about the United States of America and who we are. Politicians, former military officers, former intelligence officers are allowed to participate in the public debate, in the political conversations that go on. And this, saying that people should be put to death is more of this, pseudo tough guy stuff that goes on as part of the performative politics, which actually isn't useful in any way, shape, or form, but is also to distract from so many of the other problems and failures of the administration writ large, from the rising cost of groceries and on and on. So the fact of the matter is completely out of bounds and completely corrosive to any type of public or political discourse.
All right, well, that's a good place for us to take a short break. We've been talking about the international and U.S. laws that apply to the U.S. airstrikes that have destroyed 22 Venezuelan and Colombian vessels. When we return, we'll look at the broader implications of the airstrikes. Stay with us. Welcome back to Talking Foreign Policy, brought to you by Case Western Reserve University and IdeaStream Public Media. I'm your host, Michael Scharf, the president of the American branch of the International Law Association and the former dean of Case Western Reserve University School of Law. Today, we're talking about the U.S. airstrikes against Venezuela and Colombian vessels off the coast of South America. We're joined from New Haven by former State Department legal advisor Harold Hongju Ko, from New York City by Professor Rebecca Ingber, from Cape Cod, Massachusetts by retired Navy Captain Greg Noon, and from Florida by Professor Milena Stereo, the managing director of the Public International Law and Policy Group. So I want to get back to the checks and balances that used to exist in the United States government to avoid this kind of conflict. We've read about the gutting of the top lawyers from the branches of the military, as well as throughout the U.S. government. And just last week, a senior lawyer at the State Department publicly tendered her resignation over this issue and others related to it. Harold Ko, as former legal advisor of the State Department, what has this done to the normal checks and balances within the government related to a decision to deploy the military against Venezuela and Colombian vessels?
Well, what we've learned from the New York Times, and in a very good story by Charlie Savage, is that the administration in February adopted an executive order where the president and attorney general's decree about what the law is considered to be authoritative, which means, therefore, the president can simply decree that something is legal, and then the views of his legal subordinates becomes irrelevant. That converts this process of foreign policy making from the kind of bottom-up lawyering that you and Rebecca and I engaged in the government into a top-down process where the president can simply select the facts and then select the law. And then in addition to making irrelevant the views of these other top lawyers in the government, they're now removing people who might have independent judgment from these positions, leaving behind only those people who are willing to issue justifications and other kinds of excuses, and then not making those public. For example, an apparently lengthy opinion by the Office of Legal Counsel at Justice justifying these attacks for the purpose of giving immunity to people who participate in them.
Wow, this is all very Shakespearean. You know, the quote, first thing we do, let's remove all the lawyers. Well, at least Congress should be stepping up, right? Rebecca, how has the U.S. Congress reacted to these vessel attacks?
So Congress is a big tent, and I think there's been a real mix of reaction, but it has been perhaps less significant a reaction than you might expect when the president is engaging in sort of a steady stream at this point of extrajudicial killings. There are a lot of different bodies of concern in Congress. There is genuine concern across the board with the problem of drugs in this country, and I think there's real concern that what the president's been doing here is not going to help the problem, and it's probably actually going to hurt, particularly if we lose partners in drug interdictions, et cetera, and if we're focusing on the wrong drugs, the wrong boats. But there's also a lot of concern about the president using military force without Congress. And so this has been channeled into what has become fairly familiar grounds where the president is using force and Congress wants a role in decisions to use force. But I think that argument and channeling it into that under that framework kind of misses the larger picture that this isn't about sort of another example of the president using force against a real threat, or a real armed attack without sufficiently looping in Congress. Here we've got something that is radically outside that framework, and I think Congress doesn't quite have the muscle memory yet to actually grapple with it on the head-on.
Rebecca, if the votes were there, what could Congress do if it disagreed with the president's policy of destroying Venezuelan and Colombian vessels?
Well, Congress has a lot of tools at its disposal. So it certainly can vote on bills prohibiting the use of force, and it has actually done so. And I think there will be more bills to come. And as we've seen in the past, in the post 9/11 era, there were many occasions when presidents claimed powers that went beyond what Congress or the public was willing to accept once it became clear what was happening. And it took some time, but Congress did eventually push back. And you have examples of this, for example, the Detainee Treatment Act, in which Congress passed legislation insisting on humane treatment of detainees, then in light of stories that were coming out at the time about torture and abuse of detainees. So Congress can vote on these bills, they can hold hearings, they can demand information, they can withhold funding, and they also have the power of the bully pulpit. So you could see members of Congress could get out there and declare exactly what it is they see to be unlawful here. And we're only beginning to see them take advantage of that opportunity.
All right. Well, we haven't seen it yet. We've been talking about the lack of checks and balances within the U.S. government. I'm curious if the same is true on the international plane. So, Rebecca, let me ask as a follow-up. If countries believed that the United States attacks against the Venezuelan and Colombian vessels violate international law, could they vote to condemn the airstrikes at, let's say, the UN Security Council or the General Assembly, the Human Rights Council, or maybe even the Organization of American States?
There are many political fora in which states can raise concerns with something that another state is doing. And yes, the UN Security Council is one of them. Of course, the United States has a veto on the council, although it is not supposed to participate on issues that in which it is a direct party. They could raise concerns at the UNGA. My guess is that what's happening right now is that states are raising concerns bilaterally. And some of the most effective efforts at constraining other states can actually come from allies who are engaging bilaterally. And in this case, we've already seen reports that several of our allies have limited intelligence sharing with respect to what they used to engage with us on, which is interdictions of suspected drug boats. And so again, this is one of those examples of something that members of Congress might have reason to have concern with it, which is the president in fact hurting our efforts to combat the spread or the importation of drugs into this country? But in any event, certainly that is one very, very effective, I think, means of expressing concern.
And I'm glad to hear that at least countries are behind the scenes trying to convince the United States to change this policy, which all of our panelists believe is so clearly unlawful. Milena Stereo, let me ask you about another option. Venezuela and Colombia are both parties to the International Criminal Court, also known as the ICC. Could they refer the case of the attacks on the vessels to the ICC?
Yes, Michael, the short answer to this is yes. The International Criminal Court is the only permanent international criminal court. It sits in The Hague, Netherlands, and it has jurisdiction in situations where the crime takes place on the territory of a member state or if it is committed by a national of a member state. As you correctly pointed out, Venezuela and Colombia are member states. The United States is not. And so what this means is if the attacks are committed on Venezuelan or Colombian territory, so for example, the territorial sea of Venezuela or Colombia, then the ICC could potentially have jurisdiction here.
But isn't there even a provision in the Rome Statute of the ICC saying that there's jurisdiction when there's an attack or a crime on a vessel that's flagged to one of the state parties?
Correct. That's another option. So basically, for the purposes of the ICC Rome Statute, the vessel that is flagged carries the flag of one of the member states is essentially treated as if that attack were taking place on the territory of a member state. So to the extent that the attacks are taking place either in the territorial waters of Venezuela or Colombia, or they could even take place on the high seas, but the attacks are against these ships that are carrying the flags of ICC member states, Venezuela and Colombia, then these two states would have the option of referring the case to the International Criminal Court.
But Rebecca was saying earlier that this isn't even an armed conflict. So, what would be the possible charges that the International Criminal Court could pose?
Well, so the International Criminal Court has jurisdiction over 4 different crimes: genocide, crimes against humanity, war crimes, and then in more limited jurisdictional situations, the crime of aggression. Here, we can take genocide and aggression off the table. Genocide because we are not talking about the crime of genocide here, and aggression because for there to be jurisdiction over the crime of aggression, both the aggressor state and the victim state have to have essentially accepted the jurisdiction of the court, and here the United States is not a member. So that's off the table. So you really can only talk about crimes against humanity and war crimes. Let me start with war crimes. For war crimes to apply, you need to have an armed conflict. So these 2 states would essentially have to say there is an armed conflict here, and because of that, we're accusing the United States of having committed war crimes. And that's a little bit difficult here because they're saying this is not an armed conflict, and here they would have to say it is. Crimes against humanity can be committed outside of armed conflict as well, and for crimes against humanity, you would need to demonstrate that there have been widespread and systematic attacks against civilians in Venezuela and Colombia. So the argument there would have to be that there are widespread and systematic attacks against these boats, which are actually operated by civilians. So it wouldn't be an easy case, but in theory, it is possible.
So there's been 22 vessels so far, 83 deaths. Do you think that approaches the gravity that the ICC requires?
I think it would be a very, very tough argument, and sort of politically speaking, I don't think that this would actually happen. I don't think the court would actually accept this. But who knows? And to the extent that the United States continues to attack these fishing vessels from Venezuela and Colombia, I would say anything is possible.
I mean, there's a political element to this as well. Harold Koh, President Trump has imposed sanctions on judges and prosecutors of the ICC who were involved in the decision to open an investigation relating to Afghanistan back when the United States was fighting the Afghan war, and also issuing charges against the Israeli officials for what's going on in Gaza. How would you expect President Trump to react if the ICC publicly announced they were opening an investigation into the Venezuelan and Colombian vessel attacks?
Well, I think we could all expect it to be open school for more retaliation against ICC personnel, and I don't think that would be good for international criminal law, the ICC, or the world. If there's already an arrest warrant pending against Putin, to have another case brought against another member of the Permanent Five could well break the court. And I think that given all the effort that's gone into building the court, it would be a very difficult weight for this reed to bear. Ironically, it may not be attacking the biggest part of this problem, which is, I think that what we're seeing here is a multi-headed, hydra-headed approach by the administration that involves not just these boat strikes, but illegal orders, covert action against Venezuela, movement of troops, and a general effort at interventionism in Latin America that could be signaling a new kind of Monroe Doctrine or Trump's own version of Iraq. And I think that that's the bigger threat to which all of this is headed, particularly the use of the claim now that Maduro's group is part of a group called the Followers of the Sun, which is actually just a term of speech, but calling it an actual terrorist network, which would allow them to attack these people using military force without lifting the assassination ban. So I think that there are any number of avenues to challenge this. One thing that has been flagged by Captain Noon is that if they in fact pursue somebody for failing to follow orders because they thought those orders were illegal, that military officer would have a very strong defense because they would be the defendant and they'd have to prove that the orders were lawful. And obviously obeying an illegal order is what you're supposed to do. So there could be an Alien Tort Claims Act lawsuit. There could be war powers legislation. There could be other kinds of ways to respond. Rebecca mentioned cutting off intel sharing. I think all of those are probably more effective means than simply referring it to the prosecutor of the ICC, who has his own problems at the moment.
Well, Harold, back when you were just a regular professor, before you were a dean, before you were a legal advisor at the State Department, I believe I read that you used to have a very successful Alien Tort Claims Act clinic where your students would bring these human rights cases in U.S. court. Can you explain how that might work in this context?
Well, the Alien Tort Claims Act has been substantially cut back by the Supreme Court, but aliens can still bring suits against U.S. companies that have aided and abetted actions abroad. So, for example, the Colombian fisherman who survived apparently has a lawyer and could find that the actions of the United States blowing up his ship and injuring him, he's apparently nearly paralyzed, both constitute a tort in violation of the law of nations and are also matters that touch and concern the United States. So my guess is we will see an Alien Tort Claims Act suit from one of these people. In fact, it's important to note that the Southcom, the military command, seems to have two different units at cross purposes. One of them is the people who are going around blowing up boats and killing these 80-something people, but a very large group, and the captain can speak more to this, is still following its original rules of engagement, which is, humanitarian rescue of people they find in the water, as well as arrest, detention, search, seizure, and prosecution of people for drug crimes. So the question is, how are those two parts of the military command working at cross purposes?
And while we're talking about judicial approaches to this issue, let me ask about the possible role of the International Court of Justice, which hears cases between states rather than prosecuting individuals like the ICC. Rebecca, could Venezuela or Colombia bring a case against the United States before the International Court of Justice?
I think it's highly unlikely, Michael. The ICJ operates by consent, and that means that can include consent to the case at hand, so the United States could consent to the case, or it could be consent through a treaty or through prior acceptance of the compulsory jurisdiction of the court. And there was a time when the United States had accepted the compulsory jurisdiction of the court, but we withdrew that acceptance in the 80s following the court's Nicaragua decision. So at this point, it would be very unlikely to find a basis for jurisdiction unless somehow the United States government were to actually consent to the suit in particular.
Well, that's not likely to happen in the next 3 years. Greg Noon, the USS Gerald Ford Carrier Strike Group has now entered the Caribbean Sea. That's the most modern and powerful aircraft carrier strike group that the United States has. The New York Times reported last week that a few years ago, the U.S. Department of Defense ran a war game to assess the outcome of trying to oust Venezuela's president using force. Is there reason for us to be concerned that the attacks against the Venezuelan vessels are a prelude to a military incursion into Venezuela? What would be the likely result?
Well, unfortunately, there's always reason to concern with an administration that is so chaotic and really isn't coordinated. And Harold can speak to this better than any of us, as well as you and Rebecca, is how the normal coordination process would work. That's not how this works. And a perfect example of this is what's in the news about the 28-point, peace plan for Ukraine, when no one can say for sure who even wrote it. That's not how normal administrations work. The reality of it is this administration has been tossing around these little lines in their statements and in their tweets, et cetera, where they say, only 36% of Venezuelans support Maduro. And of course, that leads to then that must mean 64% would be happy to see us. I can tell you in the 30 years, more than 30 years I spent in the military, one thing I've learned is that when you drop bombs on people, they tend not to like you. And so this idea that you're going to show up and be greeted as liberators is a fantasy that we've gone through in a couple of iterations of foreign engagements before. So it's very disconcerting that we would anticipate any type of military incursion in Venezuela. I know some people have likened it to what we did in Panama back in the 80s, but nothing's as easy as any war game or any plan would set out to be. And I'd be very hesitant to engage and put ground troops in Venezuela. I think that would be an incredibly short-sighted and terrible idea.
So, Greg, you just mentioned the invasion of Panama. Now, we heard earlier in the program that Venezuelan president has been indicted for narcotics trafficking in a federal court in Miami. Harold, would the 1989 U.S. invasion of Panama to arrest the indicted president of Panama, Manuel Noriega, be a legitimate precedent for a military incursion into Venezuela? What are the parallels and differences?
Well, I think anyone would say that was an extremely unsuccessful way to resolve the issue. If it's a law enforcement issue, it ought to be addressed through law enforcement means, not military or warlike means. And what immediately happened was that Noriega claimed that he was a prisoner of war because he was taken by an invasion, and then that complicated the legal proceedings ever since. My greater fear, they don't actually want to bind Maduro over for prosecution. They simply want to kill him. After all, if they've killed 83 people who they don't think have been masterminds, why should they feel some constraint with regard to this? And then you suddenly have a situation in which U.S. military force is used for regime change in Latin America, which is something that we thought had gone out with the Monroe Doctrine and other kinds of interventionistic policies in the Western Hemisphere that were abandoned at the time of Jimmy Carter.
So we have 3 minutes left in the show, and my concluding question for all of the experts, if we have time, is what do you think are the likely effects of the U.S. airstrikes against Venezuelan and Colombian vessels on the future evolution of international law? Let's start with Greg.
Yeah, my concern is the South China Sea. Freedom of navigation operations that the United States Navy does on a regular basis against friend and foe alike. Tensions are getting hotter in the South China Sea with the excessive maritime claim that the Chinese have with their mythical 9-dash line, where they claim essentially all of that water. And I think you're creating the precedent where you can shoot at things that you even just tangentially think might be a threat. And I could see an exchange of gunfire between two superpowers in China and the United States.
Malena, your thoughts?
Sure. So I think this is a fairly dangerous idea because the argument here would be that international law is evolving in the direction that now allows states to more loosely use various exceptions to the general prohibition of the use of force. And even if you accept that this for now suits the United States and suits the Trump administration, what happens when countries like China, as Greg mentioned, start using the same exception and saying, well, we can now use force whenever we want against Taiwan or against other nations? What happens when Russia uses the same rationale? And so I think that whatever potential there is for the evolution of international law here is going in the wrong direction.
Rebecca.
Yeah, I fear that this could lead to dilution of international rules on the prohibition of the use of force, the prohibition against extrajudicial killing, on freedom of navigation of the seas. But I think the question about how international law evolves is not just about this violation here. It's not just about the breach itself. It's the world's reaction to that breach. So in the aftermath of the 2022 further invasion by Russia into Ukraine, many said this is the end of the world order, or this is the end of the prohibition on the use of force. And I really saw that differently. I saw the world reacting and so quickly, such a significant condemnation of that invasion and such clarity about what exactly had happened and that this was a war of aggression. But the U.S. government was a very important factor there and really led those efforts to rally the world in condemnation. So in this case, how the world reacts is, I think, going to affect whether or not international law does become diluted, and who is going to be the key actor here, who's going to rally efforts to make it quite clear that this is unlawful.
And Harold, we have 30 seconds for you to conclude.
I think I agree with what Rebecca has just said, but I think the greatest danger is when violence and threats of violence that begin offshore move onshore. And we have an administration now that seems to be ready to be interventionist in places like Venezuela, Nicaragua, Cuba, now with sanctions in Brazil. And if they start to move toward aggression-like tactics and embrace the aggression of Russia, then the United States has joined the forces who are attacking the bedrock framework of international law, not defending it.
All right, it's time to bring our program to a close. The airstrikes against Venezuelan and Colombian vessels are an issue of growing concern to the American people and the countries of the world. Harold Koh, Rebecca Ingber, Milena Stereo, and Greg Noon, thank you so much for participating in this important conversation. I'm Michael Scharf. You've been listening to Talking Foreign Policy.